Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about how inheritance work without a will when you have a blended family. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. So many families that I encounter are blended families, meaning that the husband and the wife have a child from a prior relationship or they may even have then children from their relationship. So they could either be each bringing their own child into a relationship or having one of them or both of them have children from a prior relationship and then they make more children together, if that makes sense. So what happens when one of the spouses passes away without a will, when we have this blended family situation? So when you have a blended family situation and your spouse passes away without a will here in Florida, essentially you as the surviving spouse will inherit 50%, and the children of the deceased spouse, the biological children or lawfully adopted children of the deceased spouse, will inherit the remaining 50% of the estate, if that makes sense. There's some special rules when it comes to homestead property that are subject to probate. So if you and your spouse that passed away did not own your home as joint tenants with rights of survivorship or tenants by the entirety, and that property is now subject to probate and it was their homestead, there's special rules about that. For you as a surviving spouse, you can make a timely election under the statute, whether you want to have a life estate or whether you want to take a 50% interest in the property itself. Depending on what you choose is what you get. And the children of the deceased spouse would then have either the other 50% or they would have the remainderment interest should you have elected to take a life estate. This is why it's really important that you connect with a probate attorney to help walk you through what happens when your loved one passes away, so that way if you were to fill out your own petitions for possibly a summary administration or something like that where you don't need legal representation per se because it's a small estate, you still want to be clear as to who inherits, because many times I see surviving spouses filling out such petitions saying that they're going to inherit 100% when that's not the case if somebody dies intestate without a will here in Florida and you have a blended family. If this information has been helpful to you, I ask that you like and share with others. And as always, you can schedule a free strategy session with me at eldermeeting.com. Thanks for joining me.